come back to order as soon as people gather back around in their respective places. And Senator Hemmingsen-Jaeger, you're first up.
I'll just question, so that's okay.
Someone want to tell Senator Limmer to stop celebrating in the back and come forward and do some work today? The last official action day of the Senate Judiciary Committee this year, for him, forever. All right, Senator Hemmingsen-Jaeger, Senate File 4769. Members, the intention is to lay this bill over after we have testimony and discussion. So, Senator, why don't you tell us about your bill?
Thank you very much, Chair, Senators. Happy Friday afternoon. Thank you very much for hearing this bill. This bill, right as I start off, is a joint effort with the Minnesotans for Open Government as well as MMB, so I'm glad to see some collaboration. This bill recognizes that as the Chief's legal officer, the Attorney General serves many different functions. One is to provide legal representation on behalf of state agencies, boards, and commissions when they require representation in state or federal court in administrative hearings. Another distinct role that the AG fulfills is defending the rights of the people of Minnesota in matters such as enforcing consumer protection laws, antitrust laws, and other civil actions. This bill before you adds a new section of law to clarify that when the Attorney General brings a civil enforcement action on behalf of the people of Minnesota, state agencies are not automatically deemed a party to that action. And just for context, this issue really came to a head when the Minnesota AG joined 41 other states in litigation against Meta related to the design of social media platforms and the impact to children. Meta, in turn, serves state agencies in several states with broad discovery requests. And because the state agencies were treated as parties by the court, it was really difficult for them to challenge the limits of the discovery requests, which would have been an option had the agencies been correctly treated as non-parties. Party discovery and complex litigation requires a substantial amount of time and resources. Meta's proposed search terms were incredibly broad and hit on millions of documents across the agencies. Each agency engaged in extensive negotiations to try to reduce the number of documents required to be reviewed for production, and even then were collectively required to review over 1 million records. However, states that had laws in place to clarify the role of the AG and their status as counsel for state agencies were exempted from having their state agencies subject to this party discovery, and this bill is modeled off of those states, particularly South Carolina and Ohio. So just to be clear, This bill would not prevent any party from obtaining records through discovery means like third-party subpoenas, wouldn't curtail anyone's legal rights to request agency documents, such as through a valid data request. This bill simply clarifies that an agency is not presumptively a party to any litigation brought forth by the Attorney General, and therefore subject to broad and onerous party discovery unless the agency is actually named as a party. So I view this as a really great bill to avoid government waste. We can make sure our agencies are focusing on the job they need to do and not kind of falling into this game of just stalling from litigants like Meta from trying to just kind of waste state resources in an effort to stall their own cases. So I have MMB and the AG's office here for questions, but happy to listen to the discussion.
All right, if the testifiers are here for questions only, that's great. We'll see what we have. Is there any, well, here, I got a question for you because I like this. I think it's important. My guidance here is that the intention was to lay it over. What do you think is the path forward for this, Senator?
Thank you, Chair. I'd be happy to have it laid over for consider for omnibus. If you feel it's important to send it to the floor, I'd be happy to do this too. I do feel this is really important, like I said, to a way to curtail any government waste on behalf of people that are not part of Minnesota.
All right. Is there any discussion from members of the committee on this bill? Pretty quiet up here, Senator. People ate too much cake, apparently. That's. Yeah, everyone's asleep. I think what I want to do is going to pause for a moment because I want to consult with staff about what path forward this bill might have, because I think it'd be really helpful to get this passed this year. We're going to take a brief pause. All right, we're back. Members, it's my understanding that having had the hearing here today, that the anticipated path forward may be a floor amendment on the state government omnibus bill. If that chair is acceptable to it, and that will keep the bill moving forward rather than sending it out as a late policy bill and landing on the agenda of the Rules Committee, or at least in the inbox of the Rules Committee. Senator Limmer.
Thank you, Mr. Chair. Perhaps a question for council. Does this particular proposal expand the powers of the Attorney General, or does it simply clarify, or does it do something else?
Ms. Primo.
Mr. Chair and members, it does not affect the powers of the Attorney General. The way I read it, it clarifies the scope of the discovery and the manner of the discovery when the Attorney General is bringing forth a civil enforcement action, and when someone would have to go through the non-party subpoena process in order to obtain the records that the opposing party would like.
So, Mr. Chair,
Senator Limmer.
Question to the author. Why would we need this clarification at all?
Senator Hemmingsen-Jaeger.
Thank you, Chair. Thank you, Senator Limmer. This really kind of came about because, like I said, when the AG joined other states in that lawsuit against Meta, Meta turned back and said, you know, well, we need all of these documents with all these broad terms across all of these agencies. And I think just to prevent anything superfluous happening like that again, to reduce government waste, I think would be important to clarify this.
Okay, thank you.
Any further discussion? Senator Kreun.
Thank you, Mr. Chair. But aren't there rules of court already in place for abusive discovery practices like that? I guess my concern here is, are we shielding the agencies from producing documents and turning over information that maybe isn't part of a fishing expedition? Maybe it's targeted. Maybe the lawsuit that's brought directly pertains to that agency. Will this bill prevent an opposing party in litigation from obtaining the relevant information they need through the Attorney General's office without having to resort to third-party subpoena?
Senator Hemmingsen-Jaeger.
Thank you, Chair. Thank you, Senator Kreun. I'm going to ask my testifier next to me to answer that question, if you please.
Go ahead, why don't you introduce yourself and respond to the question.
Thank you, Chair Latz and members of the committee. My name is Chris McNulty. I serve as General Counsel for Minnesota Management and Budget. To answer your question, so again, just to clarify that the sole purpose of this bill is to preserve state agency resources and taxpayer dollars by limiting agency exposure to overly broad requests when they are not a party. So if they are named as a party, of course, they would be subject to all party discovery, and this bill would not apply to those agencies. What this is limited to is when a state agency is not a named party in the lawsuit, and to clarify that the state attorney general does not have access to all of their records, and that they can reach in and grab the records of those agencies even if they are not a party to the lawsuit. And so there are other methods of discovery, such as third-party discovery, subpoenas, which are common. State agencies frequently get subpoenas even when they're not a named party in a lawsuit. And so this really just clarifies that in the state of Minnesota, that the Attorney General, simply by bringing a lawsuit on behalf of the people of Minnesota, is not also representing state agencies as parties in that lawsuit.
Senator Kreun.
Thank you, Mr. Chair, but when the Attorney General brings a lawsuit, isn't he bringing the lawsuit on behalf of the state of Minnesota?
Mr. McNulty.
He's bringing, or they are bringing the lawsuit on behalf of the state of Minnesota, but this is not a situation, for instance, where an agency is a party, like in an instance of a regulatory action. So for instance, if someone is suing the Minnesota Pollution Control Agency because of a regulatory action, then MPCA would be a party in that lawsuit, and the litigant, be it the plaintiff or whomever the other litigant is, would have access to MPCA records as MPCA is a party. But in this case, MPCA, Department of Administration, MMB, DEED, MDH were not named parties in the Meta lawsuit. It was the Attorney General as plaintiff bringing a lawsuit on behalf of the people of Minnesota against Meta. And so the agencies were not parties to the lawsuit.
Chair?
Senator Kreun.
Thank you, Mr. Chair. What do you mean by on behalf of the people of Minnesota? Who exactly is the Attorney General representing when he brings a lawsuit?
Mr. McNulty.
The Attorney General is representing the state of Minnesota.
Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. So if he's representing the state of Minnesota, these agencies aren't independent agencies outside of the state of Minnesota. They're part of state government. They're part of the state of Minnesota. Mm-hmm. So why would a defendant in one of those lawsuits not be able to get discovery without having to resort to third-party subpoenas?
Mr. McNulty.
The records of various agencies are maintained by the agencies themselves. And so the crux of this is simply that an agency such as MMB or DHS, through the laws of Minnesota, through laws such as the Minnesota Government Data Practices Act, retain those records and data as their own siloed agency and not as part of sort of one giant enterprise records repository, I guess. And so this simply recognizes the fact that records maintained by the AGO are those AGO records, and that records maintained by individual state agencies are those individual agency records.
Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. But those agencies, as siloed as you want to make them, aren't independent entities in and of themselves. They are part of the state government of the state of Minnesota, which is the plaintiff in the lawsuit. Am I not correct about that?
Mr. Chair.
Mr. McNulty. Oh, Senator Hemmingsen-Jaeger.
Thank you, Mr. Chair. I do have a representative from the Attorney General's office if we need to be further kind of going down the AG's roles and duties, if you would like to ask them questions.
If he can add to the discussion here, come on forward.
Okay, thank you.
You just go ahead and introduce yourself first and then answer the question.
Good afternoon, Jason Plagencool. I'm the manager of the Consumer Protection Division at the Attorney General's office. Can you repeat the question? I just want to make sure I'm answering correctly here.
Senator Kreun.
Thank you, Mr. Chair. What I'm trying to get at is the Attorney General is the plaintiff in the lawsuits that we're talking about here. The Attorney General, I guess fundamentally what I'm trying to get at is who is the Attorney General representing when the Attorney General initiates one of these lawsuits? I've heard that the Attorney General is representing quote unquote the people of Minnesota. I don't know what that means. In my view, and I think what I heard was that the Attorney General is bringing a lawsuit on behalf of the state of Minnesota, yet agencies within state government of the state of Minnesota are quote unquote siloed off and maintaining their own records so they don't have to produce records through the ordinary discovery process, even though they are part of state government of the state of Minnesota. So if you could help clarify who exactly the Attorney General is representing in these lawsuits.
Mr. Plagencool.
Sure. When the Attorney General brings a civil law enforcement action, it's acting in a quasi-sovereign capacity on behalf of the public interest and the state of Minnesota. So it's acting in a law enforcement capacity. And so I think a proper analogy would be like a prosecutor in a criminal action where the matter is captioned state of Minnesota. Our actions are captioned state of Minnesota by and through the Attorney General. And so we're acting in a quasi-sovereign law enforcement capacity when we're bringing these types of cases. And in Minnesota, we have a dual executive. And so agencies are answerable to the governor under our system of government, not the Attorney General. That's part of the problem. The Attorney General does not control agencies. It can't go in and just demand records from agencies. Maybe the governor could, but not the Attorney General. And that is being exploited by defendants, unfortunately, in a number of these cases. And they're they're kind of viewing the state as a monolith when that's really not the way state government is set up.
Senator Kreun.
Thank you, Mr. Chair. It's an interesting issue because I've seen captions in lawsuits brought by the Attorney General. And I don't think they're always consistent in what they say. Is there a reason why some lawsuits the caption might be different than in other lawsuits brought by the Attorney General?
Mr. Plagencool.
It may depend in what role we're acting, because the Attorney General has many different roles. When we're acting in this civil enforcement capacity, it is always captioned state of Minnesota by and through its Attorney General. If it's a representational capacity where we're representing an agency, for example, the party name would be that agency's name.
Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. So then let's play this out then. The Attorney General brings a lawsuit and is not presumptively, under this bill, would not be presumptively representing an agency within the state of Minnesota. But let's say the defendant believes that a particular agency has documents or information that's relevant to the lawsuit. Under this bill, correct me if I'm wrong, they would not be able to get that information through the regular discovery process. They would have to issue a third-party subpoena to the agency. And in that scenario, then who would be representing the agency?
Mr. Plagencool.
So they would be subject to the normal discovery process, and Rule 45 is part of that normal process. Each agencies have internal counsel who often handle Rule 45 subpoena issues. And those independent agencies would handle the negotiation, response to the subpoena, without involvement of the enforcement agency wing of the Attorney General's office.
Mr. Chair?
Senator Kreun.
Thank you, Mr. Chair. Well, let's play that out even further in a Rule 45 scenario where there's a discovery dispute and the agency says, now we don't think that we should have to turn these documents over, and there's a motion to compel or something like that, and a judge has to make a decision, then who's representing the agency in that scenario?
Mr. Plekenpool.
It could be our office, but it would not be the enforcement division that's prosecuting the case. It would be a walled-off division that provides representation to that agency.
Senator Kreun.
And that's due to we wear many hats in the office for the state.
Mr. Chair?
Senator Kreun.
Thank you, Mr. Chair. I know that Minnesotans for Open Government have signed off on the amendment that I believe was adopted in state and local government, and I'm not going to continue to belabor the point if they're okay with this, but it does seem like the Attorney General here might be is trying to play it both ways in a sense. Like, they're representing the state of Minnesota, but, you know, if we sue you, you don't have access to all of the state of Minnesota's records. And I understand the constitutional dual executive arguments you're making. I do have a little bit of concern that it might be abused by certain attorneys general in the future, but you know, maybe my last question is like, you referenced the Meta lawsuit. Would there not be existing mechanism in the rules of civil procedure to address what you perceive as abusive discovery requests?
Mr. Plekenpool.
There certainly are, and we're not denying that. The issue is that we've seen this issue arise repeatedly, not just in Meta, but it's proliferating now, and it's burdensome on our office staff to continually litigate it. And even in Meta, we had to resort to bringing a writ of mandamus to the Ninth Circuit to resolve this issue. And so a number of states have moved forward with clarifying statutory language to avoid having to have that fight in every case they bring.
Any further discussion on Senate File 4769?
Mr. Chair.
Senator Westrom.
Mr. Chair, wondering if anybody from Meta is here, or could we hear from them and just get their side of the perspective? I share Senator Kreun's concerns, and as government, sometimes they aren't always most transparent either, and so I just wonder if we could hear the other side from Meta, or if there's anybody that would be able to represent or testify on that side of the coin to kind of get the whole thing out in front of us.
Is there anyone in the room here from Meta or any similarly situated target of an Attorney General law enforcement action that might be in that position? Senator Westrom, I'm sorry no one's coming forward.
Mr. Chair, were they invited at all? The author of the bill, did they reach out to them at all?
The fact of the hearing with this bill was publicly noticed, and anyone who wants to come forward can. So I don't know if they were invited or not, but if...
Okay. All right. Well, it'd be nice to kind of hear that, and I guess if some of them are listening, maybe they can get around to us members in the coming days.
Any further discussion from members of the committee? I am not seeing any. All right, so Senate File 4769 is laid on the table. Thank you for the discussion, members. Thank you, Senator Hemmingsen-Jaeger. Next up, Senator Kreun. Are you ready on 4404?
doing? I emailed you yesterday?
Yes, that's
Okay, got it.
If they ask a question, I'm happy to answer anything.
Do you want to testify or just hear the questions?
I can do either or. I was planning on testifying.
Yeah,
as a board.
very good. Thanks. I'll first hand it off to him.
I like him.
All right, Senator Kreun, Senate File 4404. I understand the intention is to move it on to the Senate floor. Why don't you tell us about your, well, let's see here. This is the first committee. There are 2 amendments in the packet. There's an A1 and there is an A2 drafted to the A1. So Senator, we're going to treat them both as authors amendments. Senator Kreun moves the A2 amendment to the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Kreun moves the adoption of the A1 amended as amended. All those in favor say aye. Aye. Opposed? Motion prevails. That amendment is adopted. Members, you can now discard the original bill. And we have before us to delete everything A1 amendment as amended by the A2 amendment. Senator Kreun.
Thank you, Mr. Chair and members. I'm here to present Senate File 4404, as was just amended with the delete everything amendment. This is concerning medications provided to persons detained in jails. Last session, a bill was passed. I don't believe it got a hearing in this committee that dealt with medications provided to incarcerated persons. The new law had some implementation issues. The 2025 law mandates certain medication administration in county jails. However, the implementation issues with the law, as I mentioned, such as medical professionals who argued that this law forces them to administer potentially harmful and fatal doses, violating inmate constitutional rights and creating potential liability for providers. There is a pending lawsuit over the constitutionality of the existing law. Motion for temporary injunction has been denied, but the lawsuit challenging the constitutionality of the law is still ongoing. In the meantime, the principal stakeholders here have been meeting to revise the language to clarify this implementation. The delete everything amendment we just adopted is the result of significant collaboration by several of the community stakeholders who have submitted letters in support of the delete everything amendment that's in the packet, the Sheriff's Association and the Department of Corrections. The amendment meets the operational realities of jail facilities while ensuring essential medical safeguards for those in custody. It clarifies implementation, ensures that safe administration of medical services and medications that protect the lives of incarcerated individuals. Mr. Chair, with me today is the St. Louis County Sheriff, Gordon Ramsey, to testify. And we have a representative from the Department of Corrections.
Sheriff Ramsey, we are flooded today with St. Louis County representatives. You came down to where the weather is worse, I understand. Welcome to the committee.
Yes. It was like Lake Superior out there when I walked in a few minutes ago with the wind. But Chair Latz and members of the Senate Judiciary Committee and Public Safety Committee, thank you for the opportunity to testify today. I'm Gordon Ramsey. I'm the Sheriff of St. Louis County, and am here on behalf of the 87 elected sheriffs across Minnesota in support of Senate File 4404. First, I want to thank Senator Kreun for bringing this language forward, and I want to express our appreciation to all of you, as well as our many stakeholders, community partners, and Department of Corrections who worked collaboratively to develop the DE1 amendment before you today. This has been a thoughtful and productive process, and the collaboration is reflected in the strength of this proposal. Well-intended legislation passed last session on medications for individuals in custody created really practical challenges for jails, particularly around verifying prescriptions and responding to urgent medical needs during intake. This law did not fully align with the realities of jail operations, leading to uncertainty for staff and delays in care for those in custody. Together, our corrections professionals, medical providers, legislators, community stakeholders work together to identify gaps and develop a clear, workable solution for everyone. The language before you today reflects that strong collaboration and aligns with the law with safe and effective jail operations. Speaking from direct experience in St. Louis County, the current statute is having some very real impact for individuals currently in our custody. Our jail staff, medical professionals have been navigating uncertainty and how to safely and lawfully provide necessary medications, particularly in situations involving urgent or emergent medical needs. The DE1 amendment reflects a balanced and well-developed approach. It aligns with Department of Corrections rules and acknowledges the operational realities of jail settings while maintaining critical safeguards. Specifically, the amendment refines prescription verification process to align with Department of Corrections standards, recognizing emergent situations by establishing a clear process for documentation and response, promotes consistency in how the law is applied across facilities, and enhances accountability while prioritizing the health and safety of individuals in our custody. Most importantly, this language helps ensure that we can deliver timely and appropriate medical care that in some cases is life-saving. Our shared goal is simple: to protect the individuals entrusted to our care and prevent avoidable tragedies for Minnesota families. So on behalf of Minnesota Sheriffs, I respectfully ask that you support Senate File 4404 as amended. Thank you, Mr. Chair and members, and I'm happy to answer any questions.
Thank you, Sheriff. Appreciate your being here today. Ms. Khan.
Chair Latz and members of the committee, my name is Safia Khan and I serve as the Deputy Commissioner at the Department of Corrections. The bill before you today builds on existing law that was passed last session, often referred to as the Larry Hill Act, as Senator Kreun just described. This amendment before you does not change the core principles of the original bill, the original legislation. The commitment to continuity of care remains fully intact even with this amendment. Instead, what this amendment does do is provide clarity in statute around how facilities demonstrate compliance with those requirements in practice. And that clarity is something we as the Department of Corrections support having in law. The amendment is also consistent with the interim guidance that the DOC has already put in place as we look at implementation of the law that was passed last session. Importantly, as Sheriff Gordon just stated, this language is the result of continued collaboration. We commend the Sheriff's Association for bringing all of the stakeholders together, including the DOC and the advocates who worked on the original legislation. There's shared understanding that and alignment around these changes. I want to thank you for your time, and I can answer any questions you might have for the department.
Thank you, Ms. Khan. I don't have anyone else signed up to testify, so let's see if there's any member discussion at this time. This issue's been a tough nut to crack for a while. Senator Oumou Verbeten.
Thank you, Mr. Chair. I also appreciate all the stakeholders coming together to come up with some language to address concerns. Only thing I wanted to raise was the letter from the ACLU that is suggesting a slight change on line 2.1 of the DE amendment. Right now, it strikes the language on written notice and says informs. They're suggesting defining that as either written notice or alternatively by audio or video recording, so that there is documentation of that change, I believe. Just if the stakeholders could speak to that. Did you have any conversations about if informs was sufficient or if written or audio or video recording of that change would be necessary? I'd like to hear from the sheriffs and the Department of Corrections. Thank you.
Sheriff Ramsey.
Mr. Chair, Senator, we certainly would prefer the language as written, as would be our preference.
Mr. Chair.
Senator Kreun.
Madam Chair. Thank you, Madam Chair. From my perspective, as I look at that part of the bill, I think the documentation is contained in lines 2.4, and that's documentation from the medical professionals. They have to document that in their files, and they have all sorts of ethical obligations. This wouldn't be any different than a clinic visit where they're documenting that. I think that should be sufficient. If we go beyond that and start requiring audio and visual documentation, I wonder if we would have a data practices act issue. And I don't think it's necessary to achieve the objective. And I believe that's a suggested change. I think the ACLU is still supporting the DE amendment overall.
I just wanted to make sure we had the conversation in committee, but again, I really appreciate the work everyone has done. Ms. Khan?
Chair's not there, but Chair, Vice Chair. Yes, I think I agree with Senator Kreun. I think for the department, the documentation that healthcare provider would have in the records would be sufficient. If there was a complaint that we received that documentation that they had did not match the recollection from the person ever, we would look into that, but that would be looked at just like we would in any other situation. So we think the language is fine as is and sufficient for us to ensure compliance.
Senator Westrom, I see you had your hand raised. Did you want to ask a question on this bill? Just before I go to you, Senator Limmer, there's also a letter in our packets from Michelle Gross, who I know worked on the original legislation supporting the DE amendment as well. Senator Limmer.
Thank you, Madam Chair. Well, I certainly agree with the direction of where the bill is going, but pursuing a little bit more discussion regarding line 2.1. Actually, let's go to 2.4. What if there is no documentation in the person's medical records? Then there's no backup information at all, because we struck the requirement in 2.1. I'm a little, we've had a brief history in the last few years of those that are incarcerated especially in county jails, where they've had complaints of medical ailments. They've passed out and haven't moved for hours and hours, and yet at the same time, accidents do happen. And I'm just a little concerned that either let's just say by human error, there is no documentation in a person's medical records. And if that actually occurred, there would be no written record of anything. And so as I listen to your discussion, Senator Oumou Verbeten, I'm a little more concerned that we should have a little bit more of a backup on written notice. And quite honestly, I don't think it hurts, and I don't think it's a huge bureaucratic burden for anyone either.
Yeah, thank you, Senator Limmer. As I'm reading it the person would inform the licensed healthcare professional who's responsible for the inmate healthcare, or the designee would then be able to make that decision with the record. So I think you raise a good point, but I'll go to Senator Kreun and see what the testifiers want to say.
Thank you, Madam Chair. There's a lot of requirements if you back up on the first page as well in terms of documentation, but maybe I'll let the sheriff speak to their practices and procedures, how this might play out.
Vice Chair, Senator, obviously these medical issues are of extreme concern to me as the jail administrator, as well as our from a risk management perspective. I can tell you that anytime medication is changed, any medical issues are thoroughly documented. And that is just routine because of the reasons that I just mentioned. I also believe there's significant requirements on the behalf of DOC on medical reporting.
Ms. Khan, thank you, Sheriff Ramsey.
Chair and Senator Limmer, the way that we read the language, really the bill or the amendment here is saying that if when a facility can change somebody's medication is either when they have consulted with the community provider that originally assigned them that medication, or if the person tells them that they no longer want to take that medication. And what this language on line 2.3 and 2.4 is doing is specifically saying that the jail provider has to document that that person told them in their system, so that if we were, for example, going back in and ensuring compliance with this law, we would say, okay, well, why did you discontinue? And they'll say, well, the person told us, I no longer want to take this medication. We would look at the notes and make sure that that was documented in there, that the person told them that. So I think it's maybe a little bit different than the situation that you were describing.
No comment.
I'm not seeing any other questions. Senator Kreun, I'm going to move Senate File 4404 as amended to the Senate floor. All those in favor, say aye. Aye. Opposed? Motion prevails and Senate File 4404 is sent to the Senate floor. Thank you.
All right, Senate File 4301, Senator Clark. Members, this bill here is arriving at its first committee hearing. There's an A4 amendment, which we'll treat as an author's amendment. There is an A3, why are they in this order?
This is an author's amendment to the bill. This is the compromise language from Senator Gaber's 4904. So I'd rather do this. Let's just find it out.
All right, so we're going to do the A4 amendment as an author's amendment. And then we'll address the A3 amendment on its merits. Members, the intent right now is to lay this bill over, as I understand it. All right, so Senator Clark moves adoption of the A4 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Clark, tell us about your bill.
Thank you, Chair Latz and committee. I bring you Senate File 4103. Happy to present this bill on behalf of Senator Boldon. I'm proud to be a co-law author. This bill would prohibit residential leases from restricting the ability of tenants to participate in class action lawsuits. With the author's amendment that we just adopted, it would include a penalty of $300 or actual damages, which is ever greater, and it removed the troublesome treble language that we have been striking in similar bills previously. Class action waivers force tenants to trade away their ability to defend their rights in exchange for access to housing. Many renters don't understand the implications of doing so. Tenants are stronger when they come together to address violations, especially against large out-of-state landlords who regularly refuse to address health and safety issues. The right to bring an action to address a violation of the law should not be a burden on a good faith landlord. Minnesota would not be alone in taking this step. Class action waivers were recently prohibited in Washington state, and similar statutes exist in California. This topic has also been litigated in other states, including Rhode Island, where the U.S. District Court found that class action waivers were unenforceable under the state's Deceptive Trade Practices Act. Protecting the abilities of tenants to engage in class action lawsuits will strengthen tenant rights across the state without burdening landlords. And I'll draw your attention to letters of support in your packet from Legal Aid, and I ask for your support. Senator Latz and committee, I would also note that in the A4 amendment, we did address one of MHA's concerns in this, that tenant must provide the landlord notice describing the violation, and the landlord would have an opportunity to cure the issue. So it gives the landlords 30 days once a tenant has said, hey, we shouldn't have this in here, for them to take it out. That's the bill, Senator Latz.
All right, Senator Clark, any questions for Senator Clark on the bill itself before we address the A3 amendment? I don't have any testifiers signed up to testify on the bill at this time. All right, Senator Clark, tell us about the A3 amendment.
Committee, Chair Latz and committee, the A3 amendment is an amendment that I'm working on with Senator Abler. So this is in regard to manufactured housing. Existing law allows courts to stay writs of recovery for a reasonable period of up to 7 days currently, and this would change that to 30 days. And secondarily, it would also allow, if a manufactured home has been repossessed, so to speak, by a park owner, and then they were to sell it, that any surplus funds would be returned to the manufactured home owner, not kept by the park owner, but returned to the owner of the manufactured home. So it's two pieces. Bill changes the limit from maximum of 7 days to 30 days, in which to allow you to take possession of your goods, including the manufactured home. And secondarily, if you're evicted and you aren't able to move your home, and the manufactured home park owner determines that a sale of your manufactured home is necessary, any excess dollars would be returned to the owner of the manufactured home and not kept with the manufactured home park owner. Part of the impetus behind this is that moving a manufactured home can cost up to $20,000, and it sometimes can take a bit of time to get the dollars put together. And so this allows for a little bit more time for folks to be able to be able to move their manufactured home off the property site.
Is there anyone, I don't have any testifiers signed up, anyone in the room that wanted to testify on the proposed A3 amendment? Senator Clark, do you know if the MHA was aware of the amendment that was coming here, the A3?
Senator Latz, MHA.
I know it just came in last minute, so I'm not sure, but.
Senator Latz, I'm uncertain, but MHA often does not comment specifically on the manufactured home provisions, but in more general pieces. But they have not typically commented on manufactured home parks.
I understand, thank you. Senator Holmstrom.
Thank you, Mr. Chair. Senator Clark, I know you're not the chief author here, but I guess maybe you can give a little bit of insight what the original bill and this A3, what links them together. And I know that we don't have to be germane here. I'm just trying to wonder what the connection is.
Senator Clark.
Thank you, Chair Latz. Thank you, Senator Holmstrom. Largely, it's overall tenants' rights. So but primarily manufactured homes, they may own the home, but they rent the space in the manufactured home park. So it's that rental piece that draws these two pieces together.
Senator Holmstrom.
Thank you, Mr. Chair. Yeah, I'm sympathetic to the intent of the A3, but I remember the last time we dealt with mobile home parks, we had a lot of stakeholders in the room. And just the fact that they're not in the room now and this feels last minute, I don't know that I can support it. I think there's a lot more conversation that needs to be done around it to make sure that this is done correctly.
Chair Latz.
Senator Clark.
Chair Latz and Senator Holmstrom, do know that I know some conversation has occurred. For instance, in the amendment there was that the A3, that paragraph B, which is 1.8 through 1.10, is new language. Previously, in 1.5, it was 90 days was the proposal. It's been moved from 90 to 30 days. And so those pieces have been part of Senator Abler's and others' ongoing conversation. And then the bottom part, 2.1 through 2.8, I'm not aware of any conversation, but I can tell you in the 1.5 and 1.8, there has been some conversation.
Senator Kreun. Oh, I'm sorry, Senator Limmer. I had down before Senator Kreun.
Thank you, Mr. Chair. I'm trying to follow A3. It seems like it's similar to the new tax policy that we recently responded to a Supreme Court decision where a person failed to make tax payment, did not pay attention to any of the potential cures that was provided to the taxpayer, and not only lost her house to the sale, but there was a $40,000 increase in equity that the county of Hennepin kept. And Minnesota counties have been doing that since 1935. In this case, this is a little different. It's not owing money to a tax authority. It's owing money to a person they contracted with via a contract. And I'm assuming that in the contract, it most likely states that failure to pay may result in the loss of your property. But in this case, it spells out selling the home to a park owner, and that the proceeds must be allocated first to an outstanding balance, then any liens. The question I had is, there was a 30-day requirement on lines 2.6. What if that sale took place 5 years later and that the park owner just turned it into a rental and then couldn't find the former resident? What happens then? Is there a solution or a process?
Just to let you know, Senator Clark, Senator Senator Abler is next door in HHS committee right now, and this was originally his provision. So, Senator Abler, you're kind of filling in here on that regard. If you don't know the answer to any particular question, if you want to hold off, we've sent a note over to Senator Abler to let him know there's some questions about the provision that he was the author of, and we can put a pause on this bill until he's here to answer questions on A3 if you'd like.
Chair Latz, Senator Limmer, I don't know the answer to that, so that may be a better one for that. There may be, the unclaimed property provisions that it may fall under, but I'm uncertain.
Mr. Chair,
Senator Limmer.
we have to keep in mind that a trailer home or a mobile home of some sort, they are not appreciating assets. They're depreciating. So the value to the owner of that property is having a declining balance as it goes down. I could see where a landlord could put that property into a rental scenario and keep it until its value is negated and gone forever. And that it actually would trigger an expense to haul it out and get it recycled. So I can see where a park owner could never have to pay back anything.
Correct.
And he could turn the asset that he acquires via a sale into a monthly dividend until it depreciates itself out. Oh, I see Senator Abler has returned.
Hi.
Mr. Chair,
Apparently they're a lot more casual over at HHS.
I'm sorry, I have a jacket
Committee.
sitting there, but I even brought my carrot along. But anyway,
Senator
thanks for rescuing me from the Human Services Committee to come here.
So, Senator Abler, some questions have arisen on the A3 amendment, which reflects the bill that you were advocating for, author or co-author, chief author of. Senator Limmer, did you want to restate your question for Senator Abler?
Yes, Mr. Chair. I don't know if it's a great relief to go from HHS to the Judiciary Committee, Senator Abler, but
I guess we'll find out, Mr. Chair.
we will. The A3 amendment emphasizes that the proceeds of a sale must be applied in a certain manner once the property would first be bought by a park owner to or from the home owner. And then any balance, any outstanding balance would first go to the rents, utilities, and actual costs that had accrued, and then any liens on the property. And then the surplus must be returned to the former resident within 30 days. My question is, in the event that there's a sale, there's nothing that prevents the park owner from just simply putting it into a rental status, rent it out until there is no value in the property, because these properties don't appreciate, they depreciate, and you get to a certain point that they're just worthless. And so, or a very negligible dollar amount. So I'm not sure if we're actually, this would actually force a park owner to never, he would just simply turn it into a rental that never would incur a profit on a sale, that is. But it would just basically turn into a monthly dividend of sorts. Is that what you intended?
Senator Abler.
Mr. Chair, that's an unintended consequence. The current situation is, this is like a car more than a home, as you certainly well know. And so, and part of the trouble is if you have an older one that has no value, it's worth nothing. And so this language will need some some improvement. This is the first year it's been out. But at this point, the park owner could sell it. I have one in my district that's a $180,000 home that they're 3 months away from losing, which I think is amazing. It's an effort to go after at least, as in the case of the Tyler decision, where the county sells it and then they have to give the money back, kind of like that. I think either now or at a future time, if this makes it to the floor, I would be happy to come up with additional language that clarifies simply fair treatment. That's the goal. Right now, these people have no rights and no treatment that's fair at all. And this remedy is one thing, but there's a second remedy I think that we need to come up with. And what I've tried to do in some of these mobile home situations, the first part of the bill, at least give them a little bit of time, go from 7 days to 30 days to try to get their life together. And it's up to 7 days, which I find amazing. In the second part, we're trying to give some relief so their asset has some value to the person. And I think in many cases, I believe that many of the park owners would be very cooperative and be kind and treat these individuals fairly, and it seems that some are not. So that's what best I can tell you. I would be happy to take your help.
Mr. Chairman?
Senator Limmer.
Mr. Chairman, the Tyler decision is in a way similar. We discussed that before you came in, Senator Abler. In that case, it was a relationship between the property owner and the taxing obligation. And in this case, it's between the property owner and the contract. And now it looks like, and I'm assuming that any good park owner has a pretty good contract that would describe what would happen in the event that there was a failure to make payment on a monthly basis or utility expenses that remain unpaid. And so it's a little different, and once again, Minnesota's getting in the business of negating elements of personal contract, which I always get concerned about. So, and then one last question that I had is, what if at the time of putting this property into a rental basis, 5 years go by and the previous property owner cannot be found? What happens to that equity picture, if there is any, after 5 years?
So, Mr. Chair,
Senator Abler.
I'm sure you have many things to do today. This could have been the marquee topic. I don't know, but this is, in my opinion, like the most interesting thing you could have been talking about. But again, I'm ignorant of the other wonderful topics. I appreciate the intent, what you're trying to bring, and I embrace it. And I'm not sure what the will of the committee is. If this could be adopted, I'm happy to work with members of the committee that have an interest in this to actually improve upon it. It was just discussed very briefly in the housing committee, more on the thought of it, and then you were here to think of the details, which you clearly have. So I would be really happy to see if we can't make this work even better. And even talking to some of the park owners to make it, so actually, I'm not interested in a statement bill. I'm trying to find a way to give some genuine relief. And I think with that spirit in mind, even talking to some of the private equity owners, I think that they have an interest in serving their clients as well. So I think there's a target there which we can get to, which just only begins to approximate. So that's my comment, Mr. Chair.
So I think the intention is to lay this bill over, but having vetted these provisions through the committee process here, anticipating that it might possibly show up in an amendment on the floor at some point as well. That would give an opportunity to keep it within the committee and to continue working on the language. And then if we are going to have an informational hearing a week from today on a couple of other bills. So theoretically, we could, if there's some of this conversation, I'd rather see it vetted again in this committee before dealing with it on the floor. Be my view, if it's not complete, then it should not be offered as a floor amendment. If it is complete and the stakeholders and this committee seems comfortable, then fine, but I'll oppose it on the floor if it doesn't seem to be quite ready
Mr. Chair.
for prime time.
That's very fair. So I'm using another bill as a kind of a host. I'm not harming the host by my work at this point, correct?
That's correct.
Okay.
It was our original intention to lay the host bill over.
So then you would adopt this to the bill or just leave it sitting here. Whatever you like is fine with me, so, thank you.
Senator Kreun, you had a question or comment as well before we move on?
Thank you.
Thank you, Mr. Chair. I think I see what you're trying to get at with the new subdivision 6, starting on line 1.29 of the A3. I guess, and I went through, this applies when the park owner acquires the home, and then it lists a whole bunch of statutes about various scenarios where that would happen. I guess I'm not familiar enough with motor vehicle, I'm familiar with a mortgage foreclosure, and I think what you're trying to get at is a surplus, what we would call a surplus in a mortgage foreclosure, but the difference there is that has nothing to do with a resale to a third party after the fact. The surplus is set at the sheriff's sale, and I don't really know this process well enough to know if there's an equivalent, but to Senator Limmer's point, if you're basing it on the subsequent sale to a third party, we have no idea when that will be.
Right.
So I'm happy to help get at what I think what you're trying to do is get at the surplus concept.
Yeah.
And maybe there's probably a way to do it. I'm just not sure if this is it or not.
Mr. Chair, we'll go
Senator
work on
Abler.
it. So if you want to act on this or let it lay there, I appreciate the opportunity to even get this far with it. And at the very least, I hope we can do the 30-day part so they can have some humane treatment after their world has collapsed and they're losing their home. So thank you.
Well, thank you. Senator Holmstrom, did you want to add in here? Maybe what I'm contemplating doing here is maybe if there's consensus in the committee on the 30-day part is adopting that part to the bill and not adopting the other part of the A3 and then you continue working on that part. That's just what I'm thinking right now. Senator Clarkson, you're the chief author, so you can
I like
some
it, Mr.
guidance as
Chair.
well. Senator Holmstrom?
I was about to ask the author if he's willing to accept that as an amendment, what you just said, only the 30-day part.
So basically divide the A3.
Thank you.
All right, Senator Abler, does that make sense to you?
It does, and it's a very good resolution. Thank you. And I'll work on the rest.
Okay, so now I don't have the amendment in front of me because we gave my copy to Senator Abler. So Senator Clark moves to divide the A3 amendment between lines 10 and, let's see here.
Really?
No, we divide it down here.
Yeah, that's.
Between lines 26 and 27 on page 1, right? Okay, and then, just want to delete section 3, is that easier? Okay, Senator Clark moves to delete section 3 from the A3 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. That amendment is adopted. And now we have before us the A3 amendment as amended. Just the 30-day provision, the change from 7 to 30 days on the RIS recovery. Any further discussion?
Mr. Chair?
Senator Westrom. Senator Westrom.
Mr. Chair, I guess I would urge us not to adopt this yet. Senator Abler and Senator Clark, the 7 days that we're changing, if I've got it right here following the division of the amendment, this is at the end of a multi-week or month eviction process already. So the idea that all of a sudden people can get their organized in 30 days instead of 7 days, it isn't that they've just had 7 days. It's that they've had a notice of eviction. It's that they've had a eviction hearing within 14 days of a summons, which is another half a month. And so there's been at least a month or longer process, and then you have to get in arrears, so that's usually another month or two. And so this 7 days is just a culmination of a situation that hasn't resolved itself between good faith negotiations, and the court has had to step in. And so I don't think it's, I just don't, I heard how it was represented, and I just wanted to make sure that you understood that this is at the back end of a process that's been multi-week and typically 2 to 3 months in the making, and nobody's gotten a resolution, or the party that now has 7 days, they've had many weeks prior to this 7 days, and this is just to be able to move forward because the situation is not getting resolved between the tenant and the park owner. And so I would say it's not ready to adopt, and it just drags out the process that much more when somebody has already refused to resolve it in the many weeks that have already occurred. So just wanted to make that before we move forward.
Senator Westrom, my concern, I respect what you're saying, and I know it's a longer process, but in this situation, it's not to me, it's not the same as vacating an apartment where all you have to do is maybe pack up a suitcase and move out, and if you have furniture you want to take, arrange for that. I mean, a person might not refuse to resolve, but be unable financially to resolve, but maintain the hope that they can get it done and redeem the situation up until the point of the issuance of a writ of recovery. And then all of a sudden, instead of just moving out of an apartment, they've got to find a way either to sell a manufactured home or arrange to move that at a substantial cost as well. So the next step for the tenant or the owner of the manufactured home is a lot more involved here. And so it just seems to me that 7 days might not actually be enough for that to happen. And so I guess I respectfully disagree with the conclusion you've drawn. Senator Westrom.
You know, in a lot of these cases, when it gets to this point, it is there for a reason, and because both parties are kind of at their wits' end, and nobody's got a way to resolve it differently between a mutual agreement. I mean, with what you said, there should at least maybe be some evidence that there's, you know, a friend, a parent, a third party that says, kind of like a bill we had a week or so ago, there should be some evidence that there's actually some substantial reasons that within that 21-day extension or 3-week extension that they can get it moved, and it's not just a delay tactic. And so if they've in earnest got a moving company lined up, but it's going to be 15 days instead of 7, I mean, then you've got measurable steps being taken that would be good reasons to extend it. If you don't have any payment options or a line of credit or a moving company that can get to it, they just can't get to it within 7 days, and have some written documents like that, I would say that should be part of the measurement if you're going to extend it. And I agree, it is more difficult, but it isn't just a 7-day window here, so everybody understands this is months in the making. And so I think if we did it, there should be some measurable steps that would have to be provided to say, yeah, an extension reasonably is going to let me get this moved, and it's not just a 20-some day delay. So I don't know if there's some opportunity to work on that, but that might be an idea too.
Senator Abler.
Mr. Chair, just to remind Senator Westrom and everybody else, this is a writ of recovery up to 30 days. The judge will make a decision. It doesn't say you get 30 days automatically. So there's a process. And I think the very questions to be asked will be asked and answered. At least that way, right? The most you can get now is 7 no matter what. This just says if you have a plan. And just I appreciate that. I think they just need some time, at least potentially. So that's all it's asking. Thank you, Mr. Chair.
Any further discussion on the A3 amendment as amended? Senator Kreun.
Thank you, Mr. Chair, and I normally would agree that stays of writ of recovery in a normal situation, I'm usually on Senator Westrum's side, arguing that it's just kind of routine for judges to just give the maximum amount, and in those cases, it often is a time to just prolong the inevitable and to get more time. But in this case, it does make sense. Actually, I think I agree with Senator Latz. You have to actually make arrangements to move it, which I don't know how many companies do that work, how much lead time you need to do that. And yeah, maybe it's inevitable in a lot of cases leading up to that, but I mean, if somebody might have a legitimate argument to take to trial, and then there's the writ, and now they gotta move a manufactured home. So I guess this one, going from 7 to 30 doesn't offend me.
For the record, I'm going to get a transcript of Senator Kreun agreeing with Senator Latz. Yeah, we have recorded in the journal, of course. 3 hands. All right, there we go.
3 votes.
All right, seeing no further discussion, Senator Clark moves that the A3 amendment as amended be adopted. All those in favor say aye.
Aye.
Aye. Opposed? Motion.
No.
Motion prevails. The amendment is adopted.
Mr. Chair, I'm grateful. Thank you very much.
Thank you, Senator Abler. As previously indicated, the plan was to lay this over. So Senate File 4103 as amended is laid over.
Thank you, committee.
All right, I think we are ready to bring Senator Koran back with Senate File 325. Get rid of this other stuff.
Or what? I think you're gonna have, okay, we're gonna have. You got a copy? I don't. Oh. You're handing out now, close to that.
All right, Senator Koran, we're back on Senate File 325. And I understand you and the stakeholders have been working on an amendment to address the subdivision 6 question. Members, we have being distributed the A3 amendment, and we just have one suggestion by council on that on line 5 to change the word period to process.
Thank you, Mr. Chair.
Senator Koran, would you like to see that change made on line 5?
Yes, we would, Mr. Chair. Mr. Chair,
Senator
if we could
Koran.
have a couple copies, we.
On their way.
You got it.
Yeah, got it.
So before the, we'll make that formal change on line 5 when we have the A3 amendment moved. But before we get there, Senator Koran, would you like to explain the changes that are made in subdivision 6, or would you like some of the others that were involved to do that?
Mr. Chair, I would like the true experts, and so we've got the group that's led, or there's a lot of conversations, so it'll end up to be, I think, a great workable solution, and so I think I'd like to have our testifiers cover the details.
All right, which one of you wants to start? Mr. Holitz?
Yes.
Mr. Chair, thank you. I'm happy to. We believe, so the changes in this new subdivision 6, we believe, addresses some of the concerns that were brought before us. You can see the changes in the beginning. We're trying to focus in now on individuals who receive this material during the discovery process with that amendment. So specifying that we're talking about the physical data itself being received during the discovery process. We've also importantly included in 1.8 the knowing provision, making this making it match more similar criminal type offenses, and the criminality being focused on a knowing action, knowing dissemination or publication of this Again, back to that concern about using in a way that's not contemplated under Rule 903, using to harass, intimidate witnesses, that sort of thing. Those are the two major sections. Also clarifying that this would be marked as restricted data. The point of that is that puts the obligation on the disclosing prosecuting authority to mark this data such conspicuously so that people know when they get this stuff to be very careful with it and use it in the way and the only way that it's intended, and use it appropriately. Those are the principal changes we made. Thank you.
Mr. Beeler.
Thank you, Chair Latz. That's our understanding of the changes, and we'd just like to note we appreciate that the inclusion of the words discovery process protects journalists, court observers, other individuals who are not part of the discovery process. So that limitation on obtaining during the discovery process should protect them. Things said in open court no longer protect data. Similarly, the marked by prosecuting authority provides good protections for defense counsel, and importantly, those pro se defendants who may be unfamiliar with those, with the restrictions that they receive in that data.
Mr. Beeler, you're here on behalf of the ACLU, but you were a signatory on a letter that included Anna Hall from the Legal Rights Center. Have you had an opportunity to discuss these changes in the A3 amendment with Ms. Hall or someone else from the Legal Rights Center?
Chair, I have not an opportunity. I have reached out, but have not had an opportunity to connect. I believe Ms. Hall was out of the office today, which is why she was unable to attend on her own.
Okay. Were there any other stakeholders or testifiers that wanted to comment on the proposed A3 amendment? I want to make sure we've given everyone a chance here for input. I don't see a crowd rushing to the testifier table. It's either a good sign or it's a sign that no one wants to get any deeper into this. All right, is there any discussion or questions from members of the committee? Senator Loomer.
Thank you, Mr. Chair. In the last line, there's a mention of a criminal penalty, a misdemeanor, in the event that data would be knowingly disseminated. And does this language, by not mentioning it, does it prohibit a civil action in the event that there was harm created?
Mr. Holitz.
Thank you, Mr. Chair. I do not believe that it prohibits a civil action. Again, the intention is to have a conspicuously known consequence for distributing this in the criminal context, but I don't think it, in my opinion, it doesn't touch any potential civil remedy. Thank you.
Thank you.
Any further discussion or questions on this? Yeah. All right, Senator Westland moves the adoption of the A3 amendment to Senate File 325 as amended. All those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. Any further discussion on Senate File 325 as amended? Senator Oumou Verbeten.
Thank you, Mr. Chair. I just wanted to hear from Mr. Beeler because there were a number of things that were mentioned in the letter, and this is addressing just lines 4.28 through 4.33. We did hear some really good discussion from a number of testifiers, I think, on some of the other concerns, but it would just be helpful to see if we close the loop on lines 3.21 through 3.29, the concerns on lines 2.31 through 3.8, and 2.25 through 2.27.
Thank you, Chair Latz, Senator Verbeten. We contained our discussions to those lines, 4.28 to 4.33. As Senator Koran's co-author mentioned in the other body when he presented the bill, not everybody's going to get everything they want in these bills. So we still have the ongoing concerns that we have expressed, but our chief concern, that lines 428 and 433, we believe has been resolved to our satisfaction. And we will look forward to the court's updated fiscal note, which addresses the concerns raised in 3.21 to 3.29.
Senator Oumou Verbeten.
Thank you. I think one of my takeaways is, you know, there are currently those disputes when I look at lines 3.21 to 3.29. And we heard from Ms. Deagle that there's like a lot of time sort of being wasted in trying to get this material. And then there were like 1,000 motions and only 7 objections. And so, you know, those objections may continue to happen, but in those thousands of other cases, now you'll have data access, and so it's really important to get this passed. I think my only remaining question was just understanding the concern on line 2.25 through 2.27 on where the letter says this creates a higher standard for defense attorneys than any other party. I just wasn't understanding that.
Mr. Beeler, did you want to respond to that?
Yes, thank you, Chair Latz. Senator Verbeten. The concern there and the way it was explained in our county attorney from St. Louis County may have a better explanation, is that it mirrors the state rules of criminal procedure, and that's what that is doing. Our concern there is essentially that defense attorneys who learn of misconduct prohibiting testimony in one case may not be able to translate over into another case, but there is nothing necessarily prohibiting them from seeking that through the normal discovery process. So I do believe that the court rules would be sufficient in this case, but if the county attorney would like to speak to that, they may have more information for you.
Mr. Holitz.
Thank you, Chair Latz. I guess I agree that I did not fully understand the comment in the letter, but the way I understand that provision is that this is an obligation on prosecutors to make sure that they're following the rules and following the law and protecting data that has to be protected. I do agree that this does not prevent defense attorneys from talking with each other and consulting on cases. The intention is to safeguard the data appropriately so that it's protected appropriately. Thank you.
Senator Oumou Verbeten, follow up? You're good? Anyone else? Anything to say? Senator Westland.
Just very briefly, Mr. Chair, this issue's been banging around since I've been here, and I'm in my first term, and I think Senator Latz first took a stab at it. I think Senator Seeberger and I both had bills that had informational hearings last year, and I just want to commend all of the stakeholders who've worked with Senator Koran to finally come to a place where everyone seems pretty satisfied with this. And I do appreciate the balancing act that happens here, that this really is based on the constitutional rights of a defendant to have access to information, but also to have a clear process for prosecutors to make sure that they have a meaningful way to comply and also to be protecting data that's still private. So I commend you all for your work. Thank you.
Senator Lemmer.
I wanted to join Senator Westland in commending everyone from dogging this issue down. It's eluded us for quite a few years, and I'm glad that everyone has kind of come to agreement for now. But Senator Koran, I understand there's going to be a couple openings on this committee in the next year, so you're showing a little promise to solve problems, and so I know that there's a big, long list of other senators who want to join this committee, but maybe we could move you up to the front of the line. What do you think, Sarah Latz?
Does a new member have to be from the GOP?
Well, we might need more members after election. the GOP.
Well, we'll see. Well, we certainly appreciate the promise that Senator Koran is showing here today.
Mr. Chair,
Senator Koran.
I think I've done, or I'm doing my penance. I went to Health and Human Services voluntarily. Mr. Chair, I appreciate everybody's comments, and I think the work that everybody collectively has done for the last few years certainly shows here. And I think Senator Westland said that, you know, everybody's happy, or there's great compromise, or maybe everybody's a little unhappy, and so it's a good deal. And I think the one piece you mentioned too about the missing fiscal note. When you look at it, and I hadn't had the information about Hennepin County alone, 1,034 judicial actions, and I think the fiscal note was some $3 million or whatever it is. There has to be a significant savings in excess of that just for Hennepin County alone. And so I think when we look at the impact of collectively, even though they may have the largest, we should see, or it should accurately reflect some significant savings, and I would hope that that review is accurate. But the savings across the state, not just in the dollars, but the time and due process for the cases at hand, we won't be able to measure that. And so I hope we have the ability to move forward regardless of what the fiscal note comes in. But just Hennepin County alone would save more than $3 million likely, and without any regard to the due process or the timeliness of all actions for which those transactions depend on. So we thank you, We appreciate spending the afternoon with you, and we appreciate everyone's support moving this on to finance. Thank you.
Senator Limmer, would you like to make the motion?
Mr. Chair, I move that Senate File 325 as amended be recommended to pass and move to Finance Committee.
All those in favor of the motion say aye.
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 Opposed? Motion prevails.
Thank you, everyone.
Okay, members, we've got a group of bills relating to ARMER and crime victim services funding. We're going to have an informational hearing now on 6 of these bills. So we're going to turn to that. We're going to start with Senate File 852, Senator Oumou Verbeten.
No, I should.
Thank you, Mr. Chair. We did hear my bill last year to fund crime victim services. Had a lot of really good discussion then about really the crisis that we're facing with federal cuts and the lack of funding at the state level as well for these crucial services. There are shelters that are on the verge of closing. There are entire counties that would go without advocates. These are really life-saving, life-changing services for our victims of sexual assault, domestic violence, and I think we should really prioritize getting any amount of funding that we can into that fund. I did hear from advocates that this year there's a 20% funding decrease that equates to about a $12 million gap. So a lot of work to do. I really appreciate your support, Chair Latz, in trying to find some long-term funding solutions, and we threw out a lot of different ideas. Some of those are bills that weren't referred directly to this committee, and are revenue raisers that we're hoping will get hearings in the Senate Taxes Committee. But anything that we can do here to support crime victim services is just, I think, really crucial. And I think there are also some folks who wanted to share a little bit more about that with the committee. So I will pass over to them.
Senator Oumou Verbeten, I think you might have your testifier identified. I don't. So why don't you go ahead and whoever it was that was going to testify on this matter, come on forward.
Yeah, thank you.
She's online.
Thank you, Mr. Chair.
Thank you.
Victoria Pickering's here with us and can testify.
Thank you. Ms. Pickering.
Thank you so much. Thank you to Chair Latz, Vice Chair Oumou Verbeten, and members of the committee. My name is Victoria Pickering, and I am the Training and Technical Assistance Director at the Minnesota Coalition Against Sexual Assault. I'm incredibly grateful that you took the time today to have this critical conversation about the future of crime victim services funding in Minnesota. I want to thank you for allowing me the opportunity to testify. As many of you know, MenCasa is a statewide membership coalition driving transformative culture change to address and prevent sexual violence, and we act as a collective voice for organizations and individuals committed to ending sexual violence. Our coalition represents more than 60 member programs serving victims and survivors of sexual violence across the state. I'm also here today on behalf of all 6 crime victims coalitions: Violence Free Minnesota, Mending the Sacred Hoop, the Minnesota Coalition Against Sexual Assault, the Minnesota Indian Women's Sexual Assault Coalition, Minnesota Alliance on Crime, and the Minnesota Children's Alliance. Together, our network of over 150 crime victim service providers ensures that every Minnesotan has a place to go when they are experiencing violence and crime. I'm here today to strongly support the efforts being made to address the funding gaps faced by victim service organizations in the coming years. The policies proposed in this committee would not only ensure that organizations that provide life-saving services to victims and survivors have access to level funding in the coming fiscal year, they'll also create new and sustainable funding streams that will help prevent future funding crises in our field. Crime victim services are a core part of Minnesota's public safety infrastructure. The House Public Safety Committee heard from many of our advocacy programs last week about the critical services provided by our network, and we've provided letters from those member programs to Senator Oumou Verbeten in anticipation of the hearing today. Every day, advocates are working on the front lines, answering crisis calls, helping survivors create safety plans, funding emergency shelter, accompanying survivors to the hospital and to the courts, and supporting children who've witnessed and experienced violence. Across our network, programs are already operating beyond capacity. Shelters are full, advocates are carrying overwhelming caseloads, and survivors are being placed on wait lists or turned away altogether, not because these programs don't want to help, but because they simply do not have the resources to do so. Over the last 8 years, we've seen a reduction in the amount of federal funds coming into the state to support the vital services provided by our member programs. Throughout that time, we have often had to ask the state to step in and help, and because of your support, funding has generally remained level. However, level funding from 2018 to 2026 is not really level. It doesn't account for the increased costs of wages, benefits, utilities, or other basic expenses for organizations. And it doesn't account for the continued rise in demand for services. For example, the Program for Aid to Victims of Sexual Assaults, or PAVSA in Duluth, reported a 30% increase in the number of victims requesting services in 2025 over the previous year. And as Senator Oumou Verbeten referenced, the State Office of Justice Programs has recently notified us that the Crime Victim Services Fund will be facing a $12 million cut in fiscal year 2027. This represents an overall 20% decrease in the public funds available to support services. These impending cuts would be catastrophic to our member programs across the state and to the survivors they support every day, and would likely have a disproportionate impact on smaller programs that serve rural communities, as well as culturally specific service providers. Due to the flat funding over the past several years, combined with the increased demand for services, our programs have already had to make impossible decisions. Decisions like cutting staff, cutting violence prevention and community outreach efforts, limiting their services, or closing entire facilities. And now, facing a 20% cut in funding, I want to be really clear about what this means. In our rural communities, a 20% reduction doesn't just mean fewer services. It could mean the loss of the only domestic violence program serving that particular area. Our few remaining standalone rape crisis centers and children's advocacy centers will face even greater pressure to merge with larger organizations or close their doors entirely. When a program disappears, survivors don't stop needing help. Instead, they have nowhere to go. They may stay with an abusive partner, they may become homeless, or the violence may escalate with consequences not only for the survivors, but for children, neighbors, first responders, and our communities at large. Crime Victim Services coalitions and our member programs are not asking for expansion. We're asking to maintain what already exists, to keep shelter doors open, keep advocates in their roles, and to ensure that when someone reaches out for help, there's someone there to answer. Minnesota has long been a national leader in addressing domestic and sexual violence, and the coordinated community-based model we've built works, but only if it's sustained. So this is a pivotal moment for us, and Chair and members, the question before you is the same one you may have heard before. What are you willing to lose? Because without this investment, we will lose services, we will lose capacity, and ultimately we risk losing lives. So we urge you to support this funding and stand with survivors across Minnesota. And we thank you greatly for your leadership and your commitment to safety in our communities. And I'm happy to take any questions that you might have.
Thank you so much, Ms. Pickering. You did such an amazing job just talking about what's on the line here for the providers who meet people in some of the most challenging moments in their life. And I think when you shared, we don't want to turn anyone away. That's really what it comes down to. People who are brave enough to come forward and to seek help should get it. And, this committee is about public safety and ensuring that victims receive justice. This is, I would say, one of the most important ways that we do that is making sure that they receive the support that they need after experiencing things that they never should have had to experience. So this is really crucial to ensuring public safety in our state and ensuring justice for our victim survivors. Any questions, members? Okay. All right, we're going to move to Senator Clark, Senate File 4956. When you're ready, Senator Clark.
Thank you, Vice Chair Oumou Verbeten. Good afternoon, members. I'm here today to present Senate File 4956. Let me start again. I'm here to present Senate File 4956, a bill that's going to help improve emergency response times, especially during large-scale emergencies and high call volume events for the metro region. Right now, if a call comes into 911 center, the operator has to gather information, figure out what's happening with the emergency, and if the call is outside of their jurisdiction, then figure out who the appropriate 911 call center is. They have that very nicely put together in a tree system, and contact them, often directly by phone. And if it's a high volume event, the phone lines may be backed up, so it becomes problematic. So we need a solution. And that's what this bill does. This bill appropriates funds for a unified 911 center, a unified 911 center awareness platform, which allows call centers to communicate directly with each other in real time. With such a 911 uniform platform, a 911 operator can take and enter information directly into the appropriate jurisdiction's dispatch system, which allows for faster coordination rather than needing to pick up the phone, hope that they answer, and then have them type the information in. So it gives us a bit more efficient use of resources, allows emergency responders to dispatch more quickly, which is what we want 911 to do. So the funding in this provides the development and then an implementation of the system, as well as 2 years of ongoing maintenance. I'll turn it over to my testifiers. I have 3, including Commissioner Beer.
Thank you very much, Vice Chair and Senators, members. Thank you so much. My name is Dave Beer. I am a commissioner in Scott County where we work to restore hope and transform lives. The high number of public safety answer points, or PSAPs as they're well known, in the metro region, along with their closed borders, requires daily working relationships among the region's PSAPs, including the need, as was mentioned, to transfer calls and data between one another, which obviously takes time, and time is of the utmost importance. The MESB and its PSAPs has long recognized that need for PSAPs to exchange computer-aided dispatch data, or CAD, commissioning a study in 2017, successfully lobbying for CAD-to-CAD interoperability to be included in the 2019 to 2021 statewide Emergency Communication Board strategic plan, and finally releasing RFP in 2023, which might be a shocker, but was not awarded due to the higher than anticipated costs. The MESB strongly believes that this unified 911 awareness platform, which will allow PSAPs to seamlessly share CAD data with one another, will have a positive effect on public safety in the metro region, which I think goes without saying. And it will also particularly help save lives in motor vehicle accidents, which we'll hear a little bit more about as I pass it to my colleague, Tony. Thank you.
Thank you, Commissioner. And you can begin just by stating your name and title for the record.
Excellent. Thank you, Madam Chair, members of the committee. My name is Tony Martin. I'm the Emergency Communications Director with the Hennepin County Sheriff's Office. We do dispatching in 911 for 39 of the 45 cities within Hennepin County, and I'm here to express my strong support for this bill. Just to give some context and just some day-to-day operational, every day across the metro area, hundreds of medical emergencies and traffic accidents require coordinated responses from EMS, fire, and law enforcement, and as of most recent with many dispatch centers and areas is alternative responses, and they're utilizing the system as well. When someone calls 911 and multiple responders arrive quickly, that means the system worked. But we all know it can work better, and it can. Right now, when 911 centers are not connected, each medical or traffic incident often requires phone transfers, follow-up, and repeat information that's already been gathered, meaning we're asking the same question from our callers multiple times. For calls on the highway and interstates, that can include multiple additional transfers to Minnesota State Patrol or the appropriate EMS provider. These extra steps do add time, introduce the possibility of error, slow coordination, and at moments when seconds truly matter. We've already seen what's possible when these barriers are removed. In recent years, Ramsey County has several neighboring counties that have invested in direct point-to-point CAD connections. Today, they're connected to Hennepin, which is our center, Anoka, Washington, and Washington counties and Alina EMS. These connections have proven produce measurable and life-saving improvements. They reduce call processing times, cut human error, and increase shared situational awareness in several cases. These improvements have directly contributed to saving lives. But significant gaps remain, and many metro PSAPs, and including statewide PSAPs, aren't connected, including 7 dispatch centers within Hennepin County that we work with daily. Some also bordering the counties are isolated from this shared network. This is a real consequence. It's a metro-wide connected system would change that. A unified awareness platform would allow the initial 911 caller to gather the information or provide the information once, and then dispatchers can share it with a single click. Send instantly and all relevant partner dispatch centers with no repeated questions, manual delay, faster, more efficient dispatching. Within that. For reasons, I respectfully urge the support of this. The platform will save seconds, 2 minutes, and ultimately those seconds will save lives. It'll also strengthen our daily operations from day-to-day calls, but also large-scale events and when we need that interoperability immediately. So I thank you for your time and here to answer any questions you may have as well.
Thank you so much. To our last testifier, if you can just begin with stating your name and title for the record.
Thank you to the chair and members of the committee. My name is Scott Haas. I'm a captain with the Scott County Sheriff's Office, and I oversee the 911 Communications Division and our Emergency Management Division. To put this in context, in the city of Shakopee, we have a large number of events where we host. We also have a large number of industrial buildings that are susceptible to having problems. When there is a large incident, whether it be a law enforcement incident or a fire incident, we need to get mutual aid so our initial responders have the right support to ultimately resolve that emergency. For us, Scott County Dispatch takes care of the city of Shakopee. However, our nearest mutual aid partners fall under Chanhassen and Chaska is a phone call to Carver County Sheriff's Office for their 911 response. Then if we need Eden Prairie resources, it's a separate phone call to Eden Prairie, a separate phone call to Bloomington's Dispatch Center, potentially another phone call to Hennepin's Dispatch Center, and potentially another phone call to the Dakota County Communication Center to get mutual aid resources for that one incident. Each one of those phone calls can easily last more than 60 seconds. And as was mentioned earlier, while this is happening, our radios are extremely busy. 911 calls continue to flood the center. This is highly inefficient, as we know that seconds count, especially in something like a fire, where a fire can double in size every 30 seconds, or an incident where not having the appropriate response can escalate a situation instead of appropriately de-escalated. We need to get the results and get support in quickly and effectively. I also want to highlight that this solution is not just a dispatch-to-dispatch connection. As a sheriff's deputy of many years, when I would respond to a mutual aid call outside of my primary jurisdiction, all I would see on my screen was a message saying assist other agency and a location. I would not have access to any mapping information, would not be able to see where the other officers were established, and ultimately, at the time where it's most important, I was flying blind into another jurisdiction. So this solution is highly effective. It creates a shared capability that enhances all of our responses throughout this area, and ultimately makes us safer and brings 911 a little bit closer to what people expect it to do.
Thank you for your testimony. Members, are there any questions? Okay. Well, thank you, Senator Clark, for bringing this forward. Thank you again to all of our testifiers. We're going to move to the next bill since we're doing a series of informational hearings. So up next is Senate File 4772. Good morning.
Thanks for hanging out.
Senator Seeberger, did you want to offer just some words on the importance of the bill?
Thank you, Madam Chair. And I have two bills, but they're dealing with the same thing. So we've been having this conversation about our ARMER radio system for many, many years here in this committee and the funding necessary to keep it going. Right now, ARMER is funded and maintained through a patchwork approach, with MnDOT owning and operating the backbone, using 911 and trunk highway funds to operate and maintain the system, and counties and cities responsible for their infrastructure operating costs, which are paid out of property tax dollars. I remember my first year here in the Senate, I was approached to carry a bill to fund the system with, I want to say something like $200 million, which we did not have. But it highlights the need of this system and the real need for a stable and reliable funding source. My bill 4772 is not that. What it is it's a $10 million grant from the general fund to the Commissioner of Public Safety for grants to the cities and tribal entities, local units of government, for ARMER radio purposes. The second bill that I have is 4990, which has an amendment. 4990 sets out a funding mechanism, but there's an amendment to kind of go backwards a little bit and establish a task force to study long-term funding, governance, and sustainability of the ARMER system, and to make recommendations to the legislature next session so we can move towards a statewide solution for our emergency communications. These two bills represent the ongoing conversation of how do we fund this important backbone of our emergency communication system I believe I have a few folks up here who can speak to both of these bills.
Thank you, Senator Seeberger. Welcome back to the testifier table. You want to begin, Commissioner Beer?
Thank you very much. Good afternoon again. Me again, Dave Beer, Scott County Commissioner. Again, once again, we tried to restore hope and transform lives in Scott County. Can't say that enough. Today we are talking about ARMER, the statewide infrastructure system that has been, key phrase, has been, an effective public safety comm system forever, which seems like forever. When it works, it works. And when it doesn't, lives are absolutely at stake. Can't underscore that enough. The original concept of the state building the backbone, as was mentioned, with counties and cities adding their own subsystems to meet coverage and capacity needs, might have made sense in the 90s, as many things did, but not now. The ever-increasing patchwork type approach to funding no longer meets the need and jeopardizes safety, which is what we do not want to do. The current practice of local entities having individual maintenance contracts to maintain locally owned ARMER infrastructure is not a cost-effective use of taxpayer funds. Statewide contracts would produce cost savings for taxpayer dollars immediately. That would happen immediately. Given the vendor's practice of requiring infrastructure platform changes every 5 to 10 years or so, which requires substantial capital investment, the current ARMER model of local and state infrastructure ownership needs to be reviewed and modernized. I think modernization has been a key phrase around the session this year for many different areas and for many good reasons. If only to assist in aligning 87 counties plus the municipal and state capital budgeting processes. While we would like to see this underlying bill pass, we understand this issue is a complex one, and it was mentioned a task force is a good first step. Task force has been drafted with the Department of Public Safety and was adopted by the House. Department, by the way, Department of Public Safety did agree to absorb the cost if that task force moves forward, so that's always a good thing. So the ARMER system must find a dedicated and sustainable funding source. I want to say it again, the ARMER system must find a dedicated and sustainable funding source for infrastructure operations, maintenance, and capital replacement. Good policy requires good and full partnership. And we feel like we're holding up our end of the bargain, and we ask higher levels of government, such as you, to do the same. Seamless systems do save lives, they do. Siloed systems cost them. Thank you very much for your time.
Thank you so much. We'll move to you, Mr. Haas.
Thank you again, Madam Chair and members of the committee. Over 2 decades ago, some leaders in this state recognized the need for a statewide shared communication system. They built what we now refer to as the ARMER radio system. It's been successful in so many instances, but it's also successful in day-to-day operations. It's used thousands and thousands of times every day. The initial standard was to build out a system that was designed to provide 95% coverage for mobile radios in outdoor conditions. This was sufficient to start the system. It provided enough towers and repeaters so that it met the needs of the initial users, those MnDOT and State Patrol users. Then the local entities started migrating onto the system and received some support from the state through bonding funds. As members created local enhancements, this added additional tower sites and repeaters to meet the needs of local police, fire, and EMS users. It's key to understand that this is one network. The local enhancements that have been created by local entities and funded by local entities are part of a shared system. So the repeaters and the towers that are added to by local entities are used by state users, by regional users on a daily basis. This patchwork system that was put together was a necessity back in the day. However, it's time to revisit that. This patchwork solution does create some vulnerabilities for the system. If we have different entities creating different standards for maintenance, we can compromise the system. If just one county was unable to pay for an upgrade, that could compromise the entire system. Everything, because it's one shared computer system, has to be on the same page, has to be at the same level. If we have a cybersecurity incident that occurs in one of those local enhancements, the impacts for that incident could be very widespread and impact a very large number of users. To put things in local perspective, this is one shared system. We have to take care of it. Scott County is a part of the Norwood subsystem, which serves the geographic area of Scott and Carver County. we own approximately 50% of the infrastructure. So that means we own buildings, we own generators, we own repeaters, battery systems, backup systems, a lot of equipment that we pay for. While we own about 50% of that system, we actually only use 16% of the actual capacity of that system. The other use of that system is regional partners and state users. So again, a shared system throughout the state's been deployed. So with that, we need a solution that ultimately takes care of us through the long haul. And forming this task force starts to create the plan for how we ultimately take care of this critical system for the next decades. Thank you.
Thank you for your testimony. Mr. Martin?
Thank you, Madam Chair. Thank you, Senator Seeberger and members of the committee. Again, my name is Tony Martin. In addition to the 911 dispatching, I also oversee Hennepin County's radio infrastructure. Lucky me. I do enjoy it, but I am here to support, obviously, this bill. I won't try to duplicate. It's been a long day, but I appreciate your time. Specifically in Hennepin, we ultimately support 18 tower sites, about 9,000 radios, which is about 1/10 of all of the radios under the ARMER system. ARMER is the backbone of interoperability communications in Minnesota. Its reliability is what allows law enforcement, fire, EMS, and alternative response responders to coordinate during daily operations and major emergencies. Reliability depends on continued maintenance, upgrade, and capital replacement. The system cannot meet tomorrow's demands if we don't invest in it today. It has, as Captain Haas mentioned, ultimately a couple of decades of longstanding records of great performance. But when it works, no one notices. When it doesn't, those consequences are immediate. Radio communication must function 100% of the time. Ultimately, agencies from across the state routinely support one another. Our infrastructure must be supported on a statewide level. We must also recognize that 911 revenue cannot ultimately we need to find a long-term funding source for the ARMER system. We have a large 911 network upgrade that will be occurring soon. With next generation 911 approaching, every dollar does need to fund that's currently there needs to go towards our 911 network as well. It cannot and should not compete against significant reoccurring capital costs for the ARMER system. That's why convening, I think, a task force is very important to find a dedicated, sustainable funding mechanism for ARMER and essentially protecting the statewide interoperability that we depend on, establishing a clear framework and investing at a statewide level will ensure all Minnesota counties to provide safe, coordinated, and effective public safety. Again, I thank you for your time.
Thank you all for your testimony. Commissioner Beer?
Yeah, Madam Chair, and members, at the risk of sounding redundant, I just want to make sure that I testified specifically on the ARMER infrastructure, which is one thing, and then there's also the myriad of radios on that that system. It's different infrastructure. Just want to make sure that I pointed that out, which I know you knew, but I can go home and sleep tonight knowing we said that. Thank you.
We appreciate the clarification. Thank you. Members, are there any questions? All right. Well, thank you all for being here to testify. Thanks for the presentation, Senator Seeberger. We have the two final bills that we are planning to have a discussion about our Senator Latz bills. So hopefully we'll get our chair back.
Madam Chair?
Senator Pappas.
Since Senator Latz is not here, I just move that we lay over Senate Bill 4258 and Senate Bill 4259. And Senator Limmer is going to second that motion.
The committee will be in recess for a few minutes. Thank you.
Members, we've got two more informational provisions left ahead of us, and then we're going to pivot to Senate File 3432. Since I'm the author of all three of the remaining pieces, I'm going to hand the gavel off.
We have a bill here, if we're ready, Senate File 4258. Senator Latz.
Thank you, Madam Chair and members. The reason we're going to have these proceedings now in the next two bills were related to finding ways potentially to fund the ARMER radio network radio replacement needs for law enforcement and emergency responders across the state. The first bill we'll look at, 4258, proposes to do that by increasing, by establishing a separate public safety radio account and increasing the existing criminal justice data communications network fee to put money into that account for that purpose. The existing fee, basically, criminal justice agencies now pay a network access charge per terminal, computer, or equipment that directly accesses the data communications network. There is a standard fee that they're already paying. What we're proposing to do is to establish a fee in statute of $100 per month for each such access point, and then of that, $50 would go into the public safety radio account in the special revenue fund. This is one proposed long-term mechanism for building up the funds to be able to do this. The last numbers I heard is it's about $250 million would be the cost of replacing all the radios in the state that need upgrading at this time. So we have been in the past kind of lurching from occasional general fund appropriations to occasional general fund appropriations. And different senators come in and say, well, my county or 3 counties, their radios are really old now. They're 20, 25 years old. We don't have the money to replace them ourselves. So we're asking the state to help, and their bill is $5 million to take care of that in their county that they represent. Sometimes the bill gets some money, sometimes it doesn't, but it's never going to take care of the whole system that way, and it's an enormous amount of public resources for us to keep doing it bill by bill, legislator by legislator, year after year. So we've been looking for a long-term steady stream of dedicated revenue to do this, and then with revenue projections we could plan out a replacement sequence over time. So that's this proposal focuses on that criminal justice agency network access charge, and I'd ask for committee feedback on the general purpose of it and also on the particular mechanism. Madam Chair.
And then Senator Latz, did you have any witnesses for this?
Nope.
No testifiers?
No, but I was, if there's any feedback from the committee, I'd love to have it.
Senator Limmer.
Thank you, Madam Chair. In just skimming through the proposal, I see on lines 2.14, we're on 4258, correct? On lines 2.14, the access charge would be $100 per month. Oh, for each terminal, computer, or other equipment. I'm not quite sure how I would visualize the cash flow on that. However, I was more concerned about the proportionality of larger political subdivisions versus small towns. Do we have a layout of how the money in certain cities would be tabulated? Has that been done yet?
Senator Latz.
Senator Limmer, no, I'm not aware of any analysis of that sort. You know, different jurisdictions have different quantities of terminals or access points that are in use. The current statute provides for a $50 connect fee per month, and that does not currently go into a special revenue fund, or at least not for this purpose. The proposal to increase that to $100 per month we're not quite sure what the elasticity is on that. My guess is there are a lot of jurisdictions that have just been on autopilot in terms of keeping the access fee. It's a fairly small amount, and they figure, well, if we have, maybe we'll, using all of it, maybe not all optimally or 100%, but we'll just keep it going. My guess is if we basically doubled the total monthly fee, some jurisdictions would take a look and say, well, maybe we don't need all of these terminals connected anymore because they're really not all being fully utilized. So I'm not sure what the projected revenue would be, and there is not any specifically proposed standards for how to distribute the funds that are raised either.
Madam Chair.
Senator Limmer.
I see in that page page in line 214 that I referenced $100 for each terminal per month. And that'd be $1,200 per year per computer terminal. And I'm wondering if there'd be a way, and I'm assuming this might be, well, maybe you can tell me, I'm assuming something. I'm assuming that this would be a cash on payment type arrangement, but is there a way to leverage the value of the money to the purchase in some way and create a financing element? It would be smart financing, but I don't have the formula off the top of my head, but then it wouldn't be such an impact on some of these smaller communities. Well, even bigger communities are going to feel the impact. There could be thousands of terminals, let's say, in some of our bigger cities. And if it's $1,200 and you have 1,000 terminals, you're bumping into the millions now. So I'm just wondering if there's a way to do some smart leveraging of money up front and then kind of pay as you go.
Senator Latz.
I think the idea was to create sort of an ongoing revenue stream, and then the money in the revenue account would be distributed on a as needed basis. I assume grant applications of some sort. So not all counties that are paying in would necessarily have a need for a current replacement, but they might in 15 years, and they would not have all contributed proportionally either, because the distribution would be based on need. You know how you. I'm not quite sure what you have in mind in terms of a smart financing plan of some sort, but you know, right now it's just, I think it's embedded in local governmental units' budgets that, you know, this is how many terminals you have they're accessing, and you just pay the fee for it, and you've got unlimited access to the data that you can connect into.
Senator Latz,
Senator Limmer.
Chair, Senator Latz, in discussion with other law enforcement, public safety agencies, there's a well-known subject that there's one particular company that kind of has a monopoly on public safety communication equipment. But I would think that there'd be other corporations around the world that would be just as good, if not better. And perhaps introducing a little old-fashioned competition might bring some prices down as well. It seems like we've wed ourselves to a particular corporation that makes all of their products overseas anyway. And so maybe we should start there and see if there can't be some costs by the, you know, put it out for bids to different companies. Because quite honestly, even in the old days when I was way back doing correction work, it's the same company 40 years ago that's doing it. And they make a good product, but they also have a very high cost per product as well.
Senator Limmer, Madam Chair, Senator Limmer.
Senator Latz.
I know what you're talking about, and I know the agency has been looking at those issues, and I think they're currently in negotiations over pricing and possibility of renewing contracts. I'm not sure if they've gone out for bid or not. I think, you know, part of the issue is compatibility with the existing system, existing radios. But But, I mean, I agree with you that there ought to be a good hard look at whether or not that's the best bang for the buck, if you will. But whichever company they go with, old radios are going to need to be replaced, and we need a revenue stream to support that around the state. The other bill that I'll be talking about is a different mechanism for raising the revenue for the same purpose, which I can go into now.
Just Senator Latz, I'm just wondering if it's also worth looking into some kind of bonds, borrowing money that then is paid off, like a revenue bonds or certificates of participation or appropriation bonds, because then you can upfront the whole system, $250 million, and then if you have a revenue source, then you can be paying them off. So it might be worthwhile to kind of look into that as an idea.
Thank you. Thank you. And I will note, as sort of overarching this whole thing now, the agency that oversees this, the Department of Public Safety, has indicated that they're looking at what they may need to do in terms of the underlying towers and infrastructure for communication, not the end user radios that link in.
Well, for sure, that would be an easier thing to pay for with bonding is physical structure, but I'm not sure what geo bonds are pretty strict, but with some other bonding, there may be more flexibility.
Yeah, Madam Chair, and the agency doesn't want to move forward right now with either of my two proposals until they figure out how they're going to replace all the basic infrastructure.
Right.
Because that, for them, would turn out to be a funding priority, because that is quintessentially the state's responsibility, where the radios have typically been the local units of government.
Well, this building was built, as is the new state office building, with alternative bonds. So I think it's worth looking into.
Great, thank you. Madam Chair, should I go into the second revenue proposal on that?
Yes.
Senate File 4259. So this one here now, rather than using terminal access fees, would utilize a surcharge on basically cell phones across the state. Do I have the wrong one? Oh, sorry. 4259 utilizes the abandoned property revenues to go into a special revenue account to fund radios. So every year there is excess money in the abandoned property fund that never gets claimed. So our thought was to access some of those funds for the same purpose. So I guess we're just throwing that idea out there as well for people to think about. It's probably not as reliable or as large a revenue stream, but it's another place that we thought of as a possibility for going to get some of these resources. And so, Madam Chair, that's all I had in terms of the informational component of the hearing, and so whenever you're ready, if we can move to Senate File 3432 for some action.
All right, Senate File 3432 is being passed out, and Senator Latz, you're going to walk us through the bill?
Yes, Madam Chair.
We have a delete all amendment.
Well, we do, and they're for two completely different purposes. So basically, the action we'll be asking is to use the 3432 jackets as a vehicle for a different purpose. But the Senate File 3432 underlying the jackets here is to create another special revenue account for public safety radio and for crime victims. And that would be funded through a surcharge on existing 911 telephone call services. So we've talked about this. Senator Limmer, I went into some detail with you last year about this as a proposal. There's an existing fee on all cell phones in Minnesota. hasn't been raised in, I don't know, 40 years or something like that, or however long we've had cell phones. But this would propose an additional fee and would use the additional revenue from that. The fee that's in here is 50 cents a month per customer. So it would raise a substantial amount of funds. And then half of the money that's raised would go into the public safety radio communication system. The other half would go into a crime victim services fund to, at least in part, replace some of the federal money that's been lost for that purpose over the years. So I guess that part is informational because that's not going to happen this year either. But what I would like to do is to add the A2 amendment to Senate File 3432, which is a delete everything amendment. And this would be Senator Pappas's proposal, I think. So if you want to hand the gavel to Senator Seeberger, and then I ask Senator Pappas to tell us about her proposal on
Thank you,
Senator Pappas.
Madam Chair and members. This is the clemency proposal that we heard previously, so I don't think we need to go through it again, but I do have an amendment to it.
You have an amendment to the A2 amendment?
I have an amendment to the A2 amendment, Madam Chair.
Is that being,
Somewhere.
we're figuring out where that is.
Actually, I think that the second amendment was the one about policy stuff and the changes that she had requested. But it looks like she's here, so would it just help to have her come up and explain that there's some changes within this amendment?
Oh, it's already in, you think?
Yeah.
Oh, it's already incorporated. Oh, okay. Yeah, Carly Stark can come up. I didn't understand that these changes were already incorporated. So in the A2, Madam Chair.
Yes, Senator Pappas.
In the A2 amendment, we did make a couple changes, and that is on line 2.31 to 3.1 and 3.2. To address stakeholder concerns raised after the last hearing, the victim confidentiality provision now includes the ability for a written statement to be confidential from the public, but is still available to the applicant unless a protection order exists. And then the other change on line 2, the lines are different. Line 3.28, that's correct, provides clarification that if the governor requests that an application be exempt from a clemency review commission hearing, that the application must be heard by the board of pardons before a decision is made, and the requirement that the application be heard at the board level in that situation was not clear in the previous language. So if members have any more questions on that, as I mentioned, Ms. Carly Stark is here, the director, that could answer any possible questions about the DE and with these two changes incorporated.
Any questions or comments on the A2 amendment? Seeing none, Senator Pappas moves adoption of the A2 amendment. All those in favor say aye.
Aye.
Any opposed say no. Motion prevails and the amendment is adopted. Senator Latz, to your bill.
That's right, it's his bill.
I'd ask members to support the bill, and the request is to move it on to finance. So when you're ready, I'll make a motion.
Senator Limmer.
Thank you. So we now are voting on a bill. I guess I can't, we can't proceed in discussing this particular budget about public safety radio accounts without raising the question of recognizing that a few years ago we raised taxes on our taxpayers by $10 billion in 1 year, increasing state spending by 40%, and yet we still don't have enough money for public safety radio communication. It certainly raises a question about priorities. And I've been frustrated as much as anyone on this committee about not having enough money for public safety and keeping not only our citizens safe, but our public safety personnel safe as well. This has always been a challenge, and it has always eluded this state. But I'm really chagrined that we have to go through all these mechanisms in order to get just a little bit more money. It seems like there just is never enough, even after a $10 billion tax increase on the people of Minnesota. I'm just, if it wasn't so serious, it would be funny, to tell you the honest truth. I know we all on this committee recognize this dire need. And I have to commend everyone for trying to find the money. But where was our priorities in the last few years? We gave money out to a whole lot of other groups, a whole lot more individuals that said they were going to provide a service on behalf of the state of Minnesota through nonprofits and NGOs, but not enough for this, or for that matter, nursing homes or even hospitals. And now we're taking our Band-Aid box out and trying to patch it up again on some of the things that are referenced in the first article and section of our state constitution, and that's keeping our public safe. Where is our priorities?
Thank you, Senator Limmer. Any other comments or questions on Senate File 3532 as amended?
Madam Chair.
Senator Latz.
Just for clarification, I appreciate Senator Limmer's perspective and comments and where we prioritize our resources. But for purposes of today, the Senate File 3432, the underlying original bill has been completely replaced with the clemency provisions that Senator Pappas added with the A2. So what we're asking members to vote on now are the changes that have been recommended by the Clemency Board itself for streamlining the mechanism there, for putting some clarifying language in with regard to notification of victims of the underlying crimes for which people are seeking clemency, and then there is a funding portion at the end to provide sufficient or increase the capacity of the Clemency Commission to process their petitions, because they have been receiving a lot and they're not able to keep up right now, so it would help get through the backlog. So those are the only, all I'm asking the members now to vote on is the Clemency Commission changes. And for this, I would hope that everyone who applies for clemency is entitled to have a hearing anyway, or have a review. There's a mechanism for screening there without having the full commission go through that process. It's subject to appeal if a preliminary screening denies the petition. But this would so this would streamline the process and provide the funding to undo the backlog. And I think for that, I think justice is better served in Minnesota if we can do that. So I'd ask members to support this bill now. So I move the Senate File 3432 as amended be recommended to pass and be referred to the Senate Committee on Finance.
On Senator Latz's motion, all those in favor say aye.
Aye.
Aye. Any opposed say no. No. The motion prevails and the bill is on its way to Finance. There being no further business before the committee, we are adjourned.
Madam Chair.
I thought I received.
But this is, other than an informational hearing or possibility of late hearings, which we can never predict, this is the last official meeting, because today's third deadline, of the Senate Judiciary and Public Safety Committee for this legislative session, which also means it's likely Senator Limmer's last official committee hearing with us as well from his service. But I also want to take the opportunity, as we do on the floor whenever our bills, our omnibus bills end up. And Senator Pappas as well, who's also retiring this year. I don't want you to leave, that's quite true. But
glad I had that closed. Mr. Chairman, it's been an utmost pleasure to serve with you and Senator Limmer and the rest of the committee for the last 10 years? Yeah, thank you.
Well, we're losing a lot of valuable institutional knowledge and individual skills and perspectives. We'll be poorer without it. We'll have to find someone to try to gather some of that skill set along the way. But thank you for everything, Senator Pappas, Senator Limmer, that you have taught me and have taught us in the Senate, and for all of your public service. It's made a real difference for the people of Minnesota and your districts. So I also want to recognize the staff, the GOP and the Senate staff, or the DFL staff that make this committee work. Ton of work involved in making it happen. Public never really sees it until there's a slowdown for some reason, and then everyone's trying to figure out what's going on. And that happens so rarely in this committee because we have exceptional staff. So I just want to shout out to everyone on both sides of the aisle that makes this committee work so well. So, and I said all staff, but let's explicitly include nonpartisan staff as well that have been involved, and our interns and so on that provide so much of the underlying work.
Yeah, where's Priya?
Did I miss anyone? Anything?
Sergeants.
Pages.
Sergeants.
Sergeants. And Joel Carlson, right. When Joel retires, we're going to put a plaque on the, well, not in this room, really, but over in G15, we're going to put a plaque on the bench seat where he has claimed as his office permanently. All right. With that said, Madam Chair, the gavel's slid down the road. Members, we are adjourned.